Welcome to NameFi Podcast. NameFi is a blockchain technology company that tokenizes domain ownership for trading, DeFi, and an ownable internet. We regularly hold Twitter spaces and have conversations with our founder friends, partners, and community members. We turn our conversations into this podcast channel. If you like it, follow us on Twitter at namefi_io. NAMEFI_IO, and join our next live NameFi space. Thank you.
Hey everyone, thanks for joining our Domains, Disputes, and Due Diligence with our friend Brett E. Lewis.
Hi, welcome. Can you hear me?
Loud and clear.
So it wasn't allowing me on because I didn't have a Twitter account, or I deleted my Twitter feed, so it would only allow me to listen anonymously. So my apologies.
No worries. Now that we have you here, that's great, because of course, as you see, if lawyers not in the room, we were just speculating ourselves.
That's what I always say. It's best to just speculate, and probably you don't need a lawyer. And if I leave you with any advice today, that's probably the best advice I could possibly give. I'm joking.
So, Brett, really appreciate that you joined the conversation as a teaser, as a warm up. I think one of our questions is that we can begin with a question, and then I'd love to kind of introduce you after you answer the question. So I think what Amit mentioned is a case where he registered very common terms, and then all of a sudden he get a UDRP because the other side seemed to be very powerful. He didn't know what to do, how to protect. He think he made a mistake himself, and
Right.
he just gave up. What do you
Right.
think? What if you were seeing from, I know this is not your case, of obviously this is not going to be a legal advice, but in general, how should domainer treat these letters, and then what's the common things that they should go through?
Sure. So, for better or worse, responding to a UDRP complaint or even a demand letter can be costly depending on who the recipient is, right? So if the recipient is a sophisticated investor who's got a portfolio of thousands of domain names and regularly deals in 5 and 6 and 7-figure transactions, it's not going to be such a big deal for them to get that letter, right? But what if it's somebody who doesn't have a ton of resources? They get a UDRP complaint or demand on a domain name that's maybe not worth that much money. They might have a defense, right? They might have a valid defense to that demand letter, but then they would have to decide whether or not they have the money or the resources to fight back, which sometimes yes, sometimes no. I recently had somebody contact me who had a good defense, but the domain name they had just adopted, it'll cost them $30 or whatever, and it was going to cost them $6,000 to defend a UDRP claim, right? So in that case, they just decided to move off in a different direction. So the first question is, before you even decide whether or not to respond to that letter, and how you're going to respond depends on, is it valuable enough, and or do you have the resources to defend it? The name itself may not be valuable, but if you yourself, the recipient of the letter, have the resources to fight off overreaching or bullying trademark claims, then you might choose to defend it just because, right? And there are certainly people who do that, but let's say that it's determined that the name is valuable enough to defend. Then the question is really whether or not factually you have a legitimate basis to defend the name, right? And so I ask a number of questions when a client contacts me about, first, obviously, what is the domain name? When did they acquire it? When was the trademark in question first used? There are geographical questions about where parties exist. So it may be that you have a trademark holder in Brazil or a trademark holder in France or Denmark, all situations that I have had, and they are asserting claims against a domain name and the registrant's in the US. And while the registrant has never heard of their Danish trademark, right, for a windmill company, or they've never heard of their Brazilian fashion brand or whatever it ends up being. So it's critical first to get the facts. I'm going to talk a lot here. You can stop me from talking whenever you want me to, like whenever you want to interject, feel free to interject. But also, let's say common dictionary word is a very good start in terms of whether you have something which is defensible or not. But I think I heard red apple, blue apple when I was trying to log in before, and it was anonymous. The word apple in and of itself is a dictionary word. It's also the meaning in English language is for a particular type of fruit that grows on a particular type of tree, right? Of course, we know that there's Apple computers, and they make a series of devices and products and television shows. But then there's also Apple surgical gloves and Apple Bank and a bunch of other uses of the word Apple that are used in trademark contexts. So Apple could be fair game for someone to use, like maybe I want to introduce my own, I want to open up a bobblehead company and I want to call it Apple. Well, I would have to do a trademark search in order to determine whether there were any companies out there that were selling bobblehead dolls under the name Apple or something confusingly similar, right? And then that might be a legitimate, let's say there aren't. I have a clear path using the word Apple. But if I register Apple and say, oh, it's a dictionary word, but my intention is to sell it to Apple, the behemoth, the 800-pound gorilla company, or even Apple Bank, then that's improper. So why I think the domain name area is so interesting and at the same time such a difficult area for people that invest in domain names sometimes is because the answer to whether or not the registration of a domain name is valid or in good faith or in compliance with the law depends upon the intent, the unwritten, unknown intent of the person who's registering that domain name. And so, I had a situation where a client registered a domain name, which is a surname, but it was also one letter off from a very, very, very famous company's trademark. And so were they registering the domain name because it was a surname, or did they register it because it was a typo for a very, very, very famous company's trademark? Right? And that is a factual question. If this goes before a judge or if it goes before a UDRP panelist, they have to crawl inside the head of the person who registered that domain name, and they've got to try to figure out as best they can what they think the intent of that person was at the time they registered the domain. So that's a kind of far-ranging answer to maybe a start of an answer to the question that you asked.
Thank you very much. Thanks for a natural warm up. And then, of course, I love the other guests on the stage to kind of have an interaction, ask question about Brett. But first, let me share my deep admiration and respect for Brett Lewis and his team by getting a chance to introduce him. Brett E. Lewis, an industry-leading attorney in the world of domain laws, dedicated himself since the very, very beginning of domain time, I think. He practiced and his team practiced domain laws, trademarks, copyrights, internet litigations. He's the founding partner of Lewis Lin LLC, a Brooklyn-based boutique law firm that's become a go-to name in high-stake domain disputes and digital IP enforcement. They established it since 2011 and has carved out a niche specializing in internet law, UDRP complaints and defense, cyber squatting litigation, ACPA, and trademark strategy. So specifically, I think we found out that Brett Lewis and his team practiced before U.S. federal law courts, USPTO, WIPO, and NF, all the venues that you can think of to protect your trademark and domains. So, and he has played both the defense and offense side, and have done very successful and great cases for their clients. And it's just a very valuable thing for us to have in our community, that you're here, and I really appreciate that you're here today, Brett.
Oh, it's very, very flattered to have been asked to speak to anyone about this stuff. So I hope that I can provide some information to people to help them to understand some of their rights better.
Yeah, so Brett, I think one thing that would naturally be a good starting questions is how you started, because of course, as an OG, you started as almost the same time when domain started, right? So I think people probably didn't think of domain as a right, or maybe they don't necessarily think of it connecting to trademark. So can you talk us through your career and maybe some of the interesting case you went through, how this industry was shaped, how you become a lawyer in the space?
So I did start pretty close to the beginning. It wasn't the absolute beginning. When I got out of law school, I went and I clerked for a federal judge in the Eastern District of New York. I had already spent a summer working at a big Wall Street law firm, and I knew I wanted to do litigation. I didn't really realize at that point that I wanted to be an internet lawyer or a domain name attorney. Um, I came back, and it was really just a confluence of factors. I kind of stumbled into the practice area almost happenstance. I very, very fortunate, because I think it's a great, very interesting field to be involved in and to have practiced in. But I mostly wanted to work with a particular partner at the law firm that I was at. She is a terrific lawyer, and later was voted, like, I think, lawyer of the year by the New York City Bar Association a few years ago. So she is a very well-regarded, prominent attorney, and just a fantastic overall person, Susan Coleman. And so I joined the IP group at Winthrop Simpson in order to practice with Susan. And it just so happened that the year was 1999, and the new laws were just being written. The Anti-Cyberspying and Consumer Protection Act went into effect in 1999, as did the UDRP. And so literally no one at this 150 or 60-year-old law firm in New York City knew anything about domain names or how to do any of this. And so I got a case, and then I got another one and another one, or a dispute, and then a litigation, and became kind of the go-to associate at the firm for this kind of thing. And what really changed the trajectory, I think, of my career, because I think a lot of lawyers who practice at big firms develop this sort of big firm mentality, where they think that everyone who is a big corporation who has a trademark is in the right, and everyone else who owns a domain name that they want is in the wrong, right? And it's a very kind of myopic view, and there's a lot of bias that goes into it. And I had a client, the firm had a client who was a domain name investor, and it was back in the dot-com boom, and firms were trying to, get a piece of that money, I think, in that business. And so they had him in, and he was working on a business venture, and they were trying to raise money for something, but he also had a portfolio of domain names, and issues would come up. And so I got an education in defending against those kinds of claims. And it was really, really formative and interesting, because I got to see the law in a very different light. And then when I was ready to make a move, I applied for a job at register.com. And even though apparently I submitted my resume like right at the end, and they were ready to hire somebody else, I came in and was like a dark horse candidate, they told me, and they hired me in part because my perspective on what constituted cyber squatting and what were legitimate rights into a domain name were different than any other attorney that they had interviewed, right? I saw things in a much more open way, and I saw the side of the respondent in a way that these other attorneys didn't see. And so I spent 3 years at register.com, which were also very interested and informative. And then I left to start my own law firm. And then eventually, maybe 6 years later, partnered with David Lin. And then that was the start of Lewis and Lin.
Amazing. Just for people's context, I know there's a lot of audience, OG in the audience. So you may already know, but register.com is one of the first 5 testbed registrar to launch and compete in the domain registration space. And it was the time when Network Solution is in monopoly. ICANN was establishing its authority, and then probably all the UDRPs were still like forming itself. And then you joined the register.com, one of the early pilots, and then you were on the defending side. Like, I think a lot of people would, just like what Amit says, anyone who are in the space probably owns hundreds, if not thousands, of domains, and every once in a while, issues and letters and complaints like that just come up, right? They definitely need someone who is on the defend mind and can tell them what rights they own, what things they, what if they do can protect their domains to be taken away from. So you started out as a defense lawyer. Like, what are a few interesting case that you've seen and then that you defended successfully?
It's an interesting question. I will name some. So if you think about UDRPs, not to draw too much attention to this, but I guess I'm drawing attention to it. An interesting one last year was Mar-a-Lago.com. So we successfully defended that one against a claim from, I guess, the Trump organization. Going back years and years, LV.com against Louis Vuitton. We successfully defended. We have other, other defense names. There are so many. Cloro.com, that just came to mind, against Clorox. Cloro means bleach in Spanish. The interesting wrinkle in that one was that the client did at some point put up PPC ads years after he'd acquired the domain name. And some of those ads went to competitive products, but we won a 2-to-1 decision on that one. I almost have to go to WIPO in the forum to look up which other names we've defended. I had one, oh gosh, what was that one? I had one.
I think it's less about the specific case that you defend, but more about like when the situation comes, the domain investors or whoever owns the names says, "Oh, what happens? Like, what should I do? Like, I have no way out." And then you come up with very interesting approach, and then you actually found that they own the right, they have the rights that they didn't even know the way to defend, like the approach and strategy, the common strategy to defend a domain ownership.
Right. What's interesting is there have been sometimes clients who have defended themselves in a UDRP process and lost, and then come to us. And I have had the experience of looking at the papers that they filed, and clients don't often know what arguments are valid to make and which ones are not. And so they may make the wrong arguments or not put other evidence in front of a panel that is important. Like, this is not really a secret. I think some of my colleagues and competitors, if I want to call them that, like Esquire or John Berryhill, would know this. But if someone's accused of registering a particular name and targeting a trademark holder, one of the things we do is ask if they have any other similar names in their portfolio, or if they registered any other domain names on the same time or on the same date that they registered the one that's being disputed, because if someone has an interest in a particular root or form of a domain name, and you can prove that by showing they've registered other names that could be the word sync, or it could be value, VALU, or it could be, if they have a history of registering that kind of domain name, then yes, it tends to illustrate that they're not targeting the trademark holder. Maybe they like registering domain names of animals. Maybe that's their thing. Or geolocations, and the name happens to be the name of a city, but it's also the name of a pool supply company in New Jersey. I had that case. So you try to find evidence or develop information that would support that the client's intent was other than to target the trademark holder.
Yeah, I think that's a very good explanations and help a lot of our domainers understand that they could have the rights if the claimed trademark owner actually doesn't monopolize the name, right?
Right. Yeah, and this is the other thing. There are many situations. So if you're talking about a famous trademark, and people misapply this terminology a lot, but a famous trademark is a thing. There is a level of notoriety where a name is a household name, and like Google is a famous trademark. It's a household name. Microsoft. I cannot, if I want to sell my own line of jeans, right? Clothing, jeans, and I want to call them Microsoft because I'm going to use Microsoft fibers in my jeans, and I want to call them Microsoft jeans. I cannot do that. And the reason I cannot do that, it's not for trademark infringement, it's for trademark dilution. It's that the trade, in a sense of a famous trademark, it becomes, the mark is valuable in and of itself because it is the only trademark of its kind. No one else uses it, right? No one else can use it. If someone else were to start selling Microsoft jeans or Microsoft, I don't know, lemonade, it would take away from the unique, all-encompassing power that trademark has to identify the goods of a single company. So if you're dealing with a famous trademark, you cannot ever register the domain name of that trademark and say, oh, but I was going to use it for something else. You just can't. But for anything else, for dictionary word domain names, or even some pretty well names like Delta is another name that comes up in examples, right? Delta is a geographical term, right? It refers to a particular type of geography. A delta, I think it's a Greek letter. It also is used by an airline and a faucet company and Delta Dental. There are many different companies. Delta's fair game as long as you're not targeting a trademark holder with it. Now, caveat, if it's likely that any domain name which is a dictionary word, which is also, the name of a big corporation, is probably already registered or in use by someone at this point. But caveat, if one were to go say, okay, I want to register delta.xyz, it's probably already taken. But if I want to do that, sure, it could be valid, but you've got to be very super careful that you don't, that you can explain your intent in registering it and that you weren't trying to target a trademark holder. And so there is that, idea that it is wide open. Like, trademarks are typically, domain names are available, but you have to be able to have a legitimate reason for why you registered them almost. And then if you register certain domain names, know that you would have a higher likelihood of inviting a some kind of whether it's a letter or a UDRP or an action in court, like whether or not your intention was to squat on a trademark holder, there's that whole other side of it where they just want that term.
Yeah, that's right. Like, I think it's very whether you can defend a domain there's many factors playing in it, and that's why you need a great lawyer, right, to help you think about any defense that you can have for holding that domain. I like to also say the next question for me to ask, and after that, I want to open up the floor because we want to have a town hall and everyone can ask our distinguished guests the question because they probably have the question in their mind for a while. My question for you, Brett, before opening up the floor, is what are a few common mistakes domainers can make that lose their defense, like that make it harder to defend their domain holding? And then people should kind of be very cautious when they act upon that.
Parking the name indiscriminately so that it monetizes. The pay-per-click is optimized to return the greatest financial return. This may be a strategy that works for some people because if they're dealing in high volumes of domain names and they only get so many disputes, they feel that it's worthwhile, or if they've offshored their business, they don't feel like they're at risk of the more serious consequences of being sued under the ACPA. But I have seen domain names that are absolutely defensible. 100%. I could win 100 out of 100 times defending them, but the client has put them to park them, and they come up with park page monetized park page ads that are competitive with the trademark holder, and that's it. It's the end of the story. It's pretty much over. Every once in a while we can defend one of those based on the facts. I mean, in a UDRP, they're supposed to prove registration and use in bad faith. So sometimes there's a timing element there that we can argue that the name wasn't registered in bad faith if enough time went by before the name was parked. But parking is probably number one on the list. Another one would be contacting a party and offering to sell them the domain name, a party who's a trademark holder.
Oh, why?
It depends. Well, if they're a trademark holder, if let's see, I'm looking at hippeas, HIPPEAS. Okay, I eat these things. Don't ask what they are. You can Google them. It's a snack. If it's supposed to be a healthy snack, who knows? Hippeas. Okay. If you register hippeas, HIPPEAS.com, first of all, it's pretty distinctive, right? So chances are you are targeting these people. But then you pick up a phone or you email them, like, hey, I own hippeas.com. You want to buy it? Like, you're showing that your intent in registering the domain name was to profit off of their trademark, even if it wasn't. So now, let's say you reach out to, it's not hippies, but it's something a little more common, like Blackwell. And there are 30 different companies or 50 different companies that use the word Blackwell in their names, okay? And maybe Blackwell is also a surname. And you reach out to 30 of them. One of those Blackwells might sue you. Maybe multiple of those Blackwells might sue you if they're trademark holders. However, you have a better defense at that point in time because you could say there are 50 Blackwell companies and I wasn't targeting them specifically. I reached out to 50 different ones who are using this and no one has exclusive rights to it. But that act of reaching out to someone and making an offer, in so doing, and not knowing what the factual context is of a particular situation, but in the act of reaching out to someone, you are taking the chance that that person is going to respond negatively. I actually have that case right now. We're defending dirtyharry.com. And I don't want to make a bad pun, or a bad joke, but it's almost like the client reached out and sent he did that. He sent solicit like emails to maybe 20 or 30 different potential buyers who were using Dirty Harry in their business names. But one of the people that he sent it to was, I believe, was Paramount Studio or Warner Brothers, or no, I think it was Clint Eastwood. So he sent an inquiry to Clint Eastwood. Clint Eastwood told Warner Brothers. Warner Brothers filed a UDRP. Right. So, Dirty Harry has taken on connotations. It started off as its own thing in the name of a movie franchise from the early 1970s through the 1980s, but it also has entered. It's a term that's entered the vernacular. So, did the client have a right to reach out and try to sell the name? I believe that he did, but is there a risk in approaching Clint Eastwood and saying, you want to go ahead and make my day punk? You want to go ahead, you want to buy this domain name? Well, do you? It's like, there's a risk. So I'm not saying that he did anything wrong per se. He didn't do anything legally wrong, although a panel will decide what they think of it. But it was an action that provoked a response. Does that make sense?
Wow. So make sure that parking is one of the problem, and then reaching out in the wrong way is the problem too.
Yes.
Yeah, because we were discussing like whether our domainers will do outreach. And by the way, anyone on the stage, feel free to chime in now if you have questions. And I'm gonna continue to ask if no one yet raise your hand or jump in to ask questions. Oh, Ira, are you unmuting yourself?
Yeah, I just had a question of, the way you were saying about Delta. If somebody does something with Olympic, I know they dramatically guard their mark.
Yes.
So there's 5 or so grandfathered Olympic or Olympia marks that are legit, but nobody else can get in there. At least so I'm told. Is that the fact?
Yeah, and Olympic actually has an extra level of protection because the Olympics actually, in their contracts with different countries, they stipulate that for all Olympics going forward, that their brand have even if not just regular trademark, but there's actually some kind of contractual thing with the countries that stipulate that you people can't use that unless it's grandfathered. Like I think in the United States, there's a region in near Seattle called the Olympic region or something like that because of one of the mountains or something like that. And it existed before you could continue to use it, but otherwise, any new company can't.
Yeah, well, I'm glad I gave Summer Olympics back to them.
Yes.
I actually contacted their legal department and I tried to trade them for tickets to the Summer Olympics. That didn't go well, but they sent me a box full of Olympic junk and said, thank you very much. We really appreciate it. But I couldn't believe it got out in the wild.
Right. Oh, Ira, is that you?
Yeah. Oh, you remember that? The long time ago.
I remember you. We met years ago, and I remember you.
Yeah, I've been around for a little while. The cyber squatter.
Who's that picture of? I don't want to ask.
I think John coined that when with Success Bank. They tried to go ahead and they started a bank, and I registered it like 4 years prior when another one went out of business. So 4 years later, they tried to UDRP me, saying I registered it to go ahead and blackmail them. And John said I must be a psychic cyber spotter then.
I actually, what I used to call it was the Dionne Warwick Psychic Friends Network defense, or not defense, but complaint. The Dionne Warwick Psychic Friends hotline complaint. So John and I were
so if they want it, it's going to cost them some big money at this point.
Yeah, I think John and I may have had a psychic connection on that one as well.
Yeah, it was pretty funny at the time, but I was pissed that it cost me whatever, $4,000 to go ahead and defend it because there was nothing there.
Well, that's always I don't want to divert this too long, but that's always the thing, right? If you're in the business of investing in domain names and then somebody wants one of your names and they file something, then it becomes it's a cost to you. But it's almost like anyone who enters this business has to know that is likely to happen at some point in time. And almost the better the names that you have, the more likely that that is to occur. Either if you have a very, very dirty portfolio of trademark infringing names and typo squat names, you are highly likely to find yourself on receiving end of disputes. But also if you have a portfolio of very, very good names that people want, you will find it happening. I had a call this morning from an existing client who was asking about filing a UDRP complaint. And what does he know? He called me up and he said they're squatting on the name. They want $37,000 for it. These people are squatting on my name. It's his last name. It's an unusual last name, but it's his last name. It's also a business name. But he's only been in that business for 3 years, and this name has been registered since long before that. He inquired about purchasing the name. They gave him a price that he didn't like. If he went ahead and filed that, that's a plan B. That's a plan B UDRP complaint, likely reverse domain name hijacking decision. And there are lots of lawyers who are happy to take that money and file those things. And so for you, taking this back for full circle, you almost can't avoid that happening if you have good domain names. But you've hopefully you're doing well enough in your business that it just becomes a cost of doing business. And then when you beat them in the UDRP, that enough of them have to come back and eat crow and actually pay a legitimate price for the name.
Yeah. Brad, I think you mentioned a word that I just recently learned, reverse domain name hijacking. It's actually a term where a domainer can actually turn from a defense side to the offense side. Can you, I assume most of the OG already know that word, whether they have used that in defending themselves and even turn it into offense, I'm not sure, but maybe other newer domainers will benefit from you explaining this term. And what are common cases you can make a case that it gives you the chance to argue for reverse domain name hijacking?
So within the context of the UDRP, reverse domain name hijacking is kind of like being slapped on the wrist with a wet noodle. It's no real sanction, right? The only thing that it does, it should provide a degree of embarrassment. It doesn't necessarily stop everyone who should be embarrassed from going ahead and filing more complaints that they should never have filed in the first place, right? And I've recently, I can't remember which one it was, but I recently defended a domain name where the party that filed the complaint against us had filed a similar complaint against another party and had gotten a reverse domain name hijacking finding for doing it, and then went ahead and just filed another one. So there's really no consequence in the UDRP context. There is a provision of the Anti-Cyber Squatting Consumer Protection Act, which is it provides for a cause of action for reverse domain name hijacking. It is a very, very specific and set of circumstances where somebody has to have lost their domain name in a UDRP dispute where the complainant misrepresented facts concerning their trademark rights. And the panel relied on the misrepresentations of fact concerning their trademark rights in order to issue their ruling. It is a much narrower set of facts than the RDNH and the UDRP. I'm trying to remember what you can get as far as damages. I think the argument is probably attorney's fees, and I know John Berryhill's made the argument for up to $100,000 in statutory damages. It's not clear to me that the statute actually does provide for statutory damages.
Interesting.
Isn't that a civil case?
Yeah. Yeah, I think maybe it will have additional circumstances. I think Todd has his hand here, and Todd is someone I really respect, who served the community very well with his Twitter space regularly held about domain laws. And Todd, thanks you for being here.
Well, it's wonderful to hear from Brett, but I'm going to have to pass to Namer Tips because he was here before me. But Brett, I think you're probably talking about your beach jet case because that because I think that was the one where they, the place Textron files against everybody, and they have been, ruled to be a reverse domain name hijacker. But anyway, I'll come up next. I got to give it to Namer Tips. Him and I see, some others been here longer than me. So go ahead, Namer Tips.
It probably was BeachJet, and I had like 5 UDRPs going last month or whenever that was, so I couldn't remember which one it was, but thank you for clarifying that for me.
Cool. Go ahead, Namer tips. Namer Tips, can you hear us? Namer Tips, we couldn't hear you.
Yeah, he's going to have to leave and come back. Hey, Brett, Brett, it is wonderful to speak to you. Reason I did, so I'm not going to promote my show. Comes on in 2 hours from now. I do it with Jeff Newman. It's called Domain Name Law. And when I first
Okay.
started doing it like 5 years ago, Brett, even Zach Muskovich, a bunch of lawyers, and now of course I'm friends with most of them, except sometimes I'm not nice to all the lawyers. I really love your attitude, and I mean, I can't wait to have you a guest on that show. But anyway, so I do it with Jeff Newman and David Michaels. But of course, we've had, John and all your, I really miss Howard New. I know you know them all. And of course, Ari's not doing it much anymore. But I know you've seen the industry grow, especially a lot of you guys have really helped develop out the aftermarket by representing domain owners. But so I wanted to say, one, just in these last 2 weeks. So what we do, we review UDRP decisions like recent ones, and that's how I knew BeachJet because we reviewed it last week, and I didn't even know we actually said some nice things about you. Probably now the week before, Brett, I probably wasn't so nice to you on this Value Max when you were representing the complainant in Value Max. Lucky, I would say lucky for your client. You probably could have kicked some ass either way, but for your client, lucky that Don Osborne was the panelist there, notoriously on the side of the complainants. But that case I won't get to. But I really thought you presented a good case there. But Value Max is used by so many different companies, and it ended up being transferred to your client, which was I love when you effectuate a positive outcome, as you lawyers would say. But you did a great job there, especially for a name like Value Max that has, across a lot of industries. But I wanted to ask you, so enough with my horse hockey. When you were talking about the PPC landers, and Jeff Newman, who's a partner of mine and also co-host on the show of I do, he has always been frustrated with these registrars who, you register a name, you don't do anything with it yet because, we're regular business people. Sometimes it takes Disney 10 years to make a movie. It takes a lot of big companies a long time to develop out domain names. Sometimes we'll register a name for a business. It's got these PPC links that are provided by the registrar, yet we're in trouble for it. So how do you, if it's PPC links that are provided by the registrar, what responsibility does the domain owner have to, in some cases, some panelists say they have all the responsibility, but how do you defend against that when it's the registrar who's put up these PPC links? Go ahead.
Yeah, I think that's ridiculous. So I want to say one thing. I have a philosophy, or I don't know if it's a philosophy. It's certainly my understanding of what is legitimate or valid registration of a domain name doesn't change based on who I'm representing. So, or it does not change, I would say, very much. I am not going to make an argument that passively holding a domain name is cyber squatting. It's just so I can win a complaint. and then turn around and come back and say, no, passive holding not by itself. What are you kidding? No, that's not cyber squatting. So like I would say the value max situation based on the PPC links to my client's product is that's what made that one, that's what greenlit that for me, right? In terms of filing it. The fact, and I said, having PPC links up to competing products is probably the biggest thing that I see that's problematic for people. If there were not PPC links to my client's products on that site, I would never have taken that on, right? Because for the reasons you say, value max is a fairly common term. But then if someone registers a domain name and they're monetizing it against a particular trademark holder, then that creates the difference there. In terms of getting back more specifically your question about registrars, I was at register.com when they and others started doing that, putting up the park pages and then monetizing them. And I think it is a really, I was going to use a vulgarity, but I am not in favor of that practice. I think if because it's, they are monetizing whatever domain names are registered through them, right? And so there are going to be a number of trademark names that get registered, or there'll be ambiguous names that aren't necessarily targeting a trademark, but they are also trademarked or in use as trademarks. And so when the registrars monetize those domain names, they're making money potentially off of trademark infringement, but they're also, like, if they're optimizing, they don't care whether or not they're infringing, but then they're throwing risk onto the domain name investors or the domain name holders, their own clients. So their customers, so I think it's absolutely ludicrous that there are panelists who will blame the registrant for that and say, oh yeah, but you registered this domain name with GoDaddy, so you knew, or you benefited because they charged you a lower price because they were making money off of monetizing that name. I think that is absolutely ridiculous. I certainly hope that's not the majority view. But in terms of what you do about it, I mean, you have to, when you register a domain name, you've got to then point the DNS to nothing or opt out of being in that, having your name parked with the registrar. But I do agree. I don't like it. I don't like that practice. I never liked it.
Thank you, Brett. And I like calling you Brett over and over again. You know how you. Victor's fantastic to have you. But Victor, leave the room. He's in on this as a listener now. But I say fantastic to have you as a guest. And we have like 3 or 4 guests per year. Have all your friends that you've known. You've already mentioned a few of them here. But also, hopefully, maybe you stop down there at NamesCon, because we were doing some panels there. I'm doing a couple with all the lawyers. I'm the only one that's not a lawyer. I went to law school, but they wouldn't. It was because I took a wrong turn and started law school. But I never did pass the bar because anyway, stopped at a bar along the way. But no, I'm doing some great panels with some lawyers. And if I knew you were going to be at NamesCon, certainly almost like to have you join us, because anyway, you mentioned a couple things that John always says. That's Barry Hill, and also my 2 co-hosts, Jeff Newman and David Michaels, if I can name drop. You mentioned going, when it comes to reaching out, you can, if there's numerous folks that are using a mark, reach out to numerous. So I'm telling this to the domain investors, right, to show that we've reached out to 20 potential people that could use this mark. As soon as you start targeting, even if it is a common term, you can get in trouble, because we get people like, this is generic, or it's it's pretty descriptive of a term. So I bought it and I contacted this one company, and they're really targeting. So you can still be caught up in targeting, like you mentioned. I'm glad you did, about, you might think you have a safe name because it's descriptive or generic, but you still can't intentionally target someone. So domain investors, sometimes think they can do that. By the way, well, one other question you can help me with my show today. We're going to be talking about registering somebody's personal names. So what type of problems do people get into when they register someone's personal name as a domain name?
So there is a section of the ACPA, the Anti-Cyber Squatting Consumer Protection Act, which says that it is cyber squatting to register a person's personal name with the bad faith intent to profit by selling it to them. So if I registered Jane Smith, for example, or Joe Jones, that's okay, as long as I don't have a particular person in mind. It's not like, maybe there are 1,000 Jane Smiths out there. It's not like I'm targeting one of them. But, I had a situation where somebody registered, I guess I could talk about this, Harj Tagger. He is one of the, I don't know if it's founders or, but he's one of the principals of Y Combinator, right? It's a very distinctive name. And they put up some weird website with I think some monetized links on it or something. And so, yeah, that runs afoul of the ACPA, right? Because they're targeting a very specific person's name and what's their intention in doing it. I mean, I suppose if you registered a known individual's name without an intention to sell it to them, and you could prove that you weren't intending to sell it to them somehow, then you wouldn't be technically running afoul of the ACPA. But anytime that anyone registers an individual's name, and it doesn't have to be a trademarked name, it can just be their individual name with a bad faith intent to profit by selling it to them, it violates the ACPA.
Well, thanks again. And I always say that, Brad, that right, they have the standing. They don't have to have a trademark. If it's their personal name, their legal name, they have standing to file an ACPA action against you. And you were right earlier. It can be $100,000 and some attorney fees. Of course, the attorney's got to ask for those fees, but usually it's not. But I'll be bringing up later today that I did Yao Ming sued me for $100,000 in one of the first ACPA cases for a domain name, and we won. But yeah, that's where it gets a little, scary for a domain investor. You own a name, and it's much nicer to get a UDRP complaint because you really can only lose the name. You can't have
Correct.
these penalties. But hey, thanks for spending your time here today with a lot of us. We appreciate it and look forward to talking to you in the future.
Absolutely. It's a pleasure to speak with you and Victor and everyone else and Ira.
Yeah, thanks so much, Brett. It's very nice to have you. If there's one takeaway that you want the audience to bring back, especially if they're a domainer, what would be that line that they should take away from today's conversation?
Oh boy, one line.
Or a few.
I don't know. I think it's just be aware of what they're doing. Be conscious if they're registering dictionary word domain names. Try not to do something silly look, it's not always silly. I know of people that do it on purpose, that will register names that are typos or that are right up against the line or over the line because they want to maximize the pay-per-click revenue by trading off the goodwill of trademarks, right? And I'm actually not here to condemn and or not condemn that behavior. But if you're not looking to invite potential lawsuits and you're not in a position to defend yourself or then just be mindful of try to be mindful of how you're using your domain names, right? There's so many different ways that people get attacked by trademark holders. Oh, you're passively holding the name. That's bad faith. Oh, you're using it but you didn't use it for you only used it for a little while. I've heard, which is a terrible kind of but it is. The monetizing domain names for PPC indiscriminately can really get people in trouble, and gotta have an awareness of how your names are being used, especially of good domain names that are dictionary word domains or they're brandable domain names. But, you know, I want to add to this, though, take a slight pivot. If you registered your domain name before the trademark holder ever came into existence, it becomes a different issue. You don't have a worry as far as cybersquatting is concerned, but you could have a worry as far as trademark infringement is concerned. And PPC that targets a known trademark it won't cost you the domain name necessarily if you can afford to defend yourself, but it could still be considered a use in commerce of a trademark which is infringing, right? So you just got to be real careful with that. That would probably be the biggest cautionary tale.
Thank you very much, Brett. Thank you for being with us. And then we look forward for more conversation like this. Domaining is definitely a journey. And then in it, you had adventures. I hope everyone enjoy it, and then everyone should pay attention to laws. And then when you are in question, go find a good lawyer like Lewis and Lin and Brett's team. And everyone, thank you very much for our conversation today. We appreciate Arif, Amit, Todd, Ira, Domain Insider, and then Paul Sink, who just got on stage. And also really, really appreciate our featured guest, Brett Lewis, for our domains dispute and due diligence. Thank you very much. And see you next Twitter NameFi space.
Thank you again for having me.